Thank you very much. Hello, everybody. Good morning. Good morning. As Meryl said, my name is Chris Posner. Let me share my screen real quick. Awesome. Oh, which slide am I on? Let's see. Oh, cool. So you can see my picture here. That's from about 7 or 8 years ago. You can see how young I was compared to I am now. Been practicing for 8 years, doing essentially pretty much everything at this point. A couple years ago, I would tell people I did door law, meaning whatever came in the door, I would do. I'm now lucky enough for the last 3 or so years to be really focusing on community associations, and at this point, all I do. So we're going to jump right in. Obviously, today, let me go to the title screen. We're talking about the screening process, developing procedures, and training your screening committee. As community association managers, I'm sure a big part of your day is spent reviewing sales and leasing applications. And then as we're gonna get into, hopefully you guys are looking at them correctly, and if not, we'll set you guys straight. And more importantly, as I'm about to go into, hopefully you even have a right to do it. So defining the role, obviously, what we're here for is the process of reviewing transfers of a property interest into community. Under the Florida Constitution, I believe it's Article 5, we as Florida residents have the right to alienate our properties. That means we have a right to convey it, meaning we can transfer ownership without undue restriction. And this transfer authority sometimes gets in the way of that. So it's very important that you review your community's documents to ensure that, one, you have the authority to even review or consider transfer applications, and two, make sure that you have the authority to review every type of transfer. In my experience, a lot of times we have communities where, for one reason or another, they're lucky to not have any issues, and then one day they deny an application and they get pushback. They come to us for help, and we look at their documents and realize, oh my God, you actually never had the authority to do this in the first place. And we've had years of this community taking in transfer fees, reviewing and denying applications. And while they were lucky for a long time, generally how this plays out is an angry attorney or owner gets involved, and we realize, oh my goodness, shouldn't have been doing this in the first place. So for a lot of our KBR classes, you're going to hear attorneys say, hey, check your documents. It's especially true today. So you really want to make sure you have that transfer review authority. Now, next point is recognizing special circumstances. When you're reviewing these applications, there's some things that might trip you up. Most times you just have your program like tenant evaluation where the owners submit an application or their tenants submit an application. They put in their information. Sometimes they have no issues. You approve, everybody's happy, they move in, fantastic. Or they close, great. But sometimes you see some hiccups. Let's say you have a pet-free community and you suddenly see a dog as well as a doctor's note might give you some pause because you might think, oh, I can't deny that we have no dogs here. But as I'll get into later, service animals and ESAs are not considered pets. So your no pet restriction would not apply. You might have a military applicant. You might have someone who says, hey, I need to build a ramp into my home, or I need to build some sort of modification to the unit. All these things might give you pause, which might impact your timeline, which again, you want to refer to your documents. You might have a certain time frame for your board or committee to turn around on an application. Generally, you see 30 days. If you don't have a time frame, you want to look at your local ordinances. I know Broward County and Miami specifically have a 45-day turnaround. And obviously, communicate the process. You want to make sure that your applications are thorough and readily available to your residents and the community so they know before they submit an application what they're getting into, and they can do their hopeful pre-screening of applicants before they waste everybody's time. So going into those special circumstances, like I mentioned before, if you have a service member applying, your time frame to turn around on that application for rental is dramatically shorter from generally speaking 30 days to all the way down to 7 days. So the moment you get it and you note that they are a service member, an active duty service member, you need to get it moving. Now, these two reasonable accommodations and modifications, I'll go over briefly, but a reasonable accommodation is a request to essentially waive a violation. So, like I said before, let's say you have a community that in their declaration says no pets are allowed. If I submit an application to community and I include a doctor's note that says I have a disability related need, my disability impacts a major life activity, and my doctor prescribed, my dog Spike to alleviate my symptoms, Most attorneys will say that letter is sufficient, and my dog is no longer a pet. It's now an emotional support animal. So I am getting an accommodation for that pet restriction. Same thing for reasonable modifications. I might have to, I'm disabled for one reason or another. I need to build a railing around my unit, which for one reason or another might not be permitted, but it might give you pause because along with my application for tenancy, you might see these, modification documents. So these are all things that when you see them in your application, flag them and make sure that if you need more information, you ask for it because, again, in certain counties like Broward and Miami, you have 15 days from receipt of an application to ask for more information or documentation. After those 15 days, you then have 30 additional days to complete your review. So it's not to say that after the 15 days, if you learn something new, you can ask for more information, but your time frame to respond may not be extended. So again, this is that timeline. So again, check your governing documents. They might have a 30-day. If you're unlucky, they might have a 15-day turnaround. Now, if you go beyond these time frames, you run the risk that if they want to deny this applicant, you might have waived your right to do so. So it's very important that once you get the application in, you do a cursory review and make sure everything is included. If you see anything missing or information that's confusing, you flag it and you ask for more information. And you keep a timeline of when you get these documents in so you can easily demonstrate if there's an issue, God forbid, you have everything detailed. You have the date you received the application, the date you confirmed it was complete and ready for review to the committee or board or what have you. You make sure that you have your consumer and background check already in the application packet. If your community does interviews, which I'll talk about later, you make sure that's scheduled and you notify the applicant, or in the case if it gets a sale, you notify the owner and the seller, or if it's a lease, you notify the owner, and in some counties, the tenant as well. You want to make sure that from start to finish, you follow that timeline because if you go beyond it and you have no good basis to extend it, you might waive your right to deny an applicant. Now, fees. This is another one of those things where oftentimes we'll see a community where they've done things right for a long time. They charge a transfer fee, they charge the move-in fees, a security deposit, all these things they charge and they have no issues until they do. And then when they come to us, unfortunately, you have to tell them, hey, you may or may not be able to charge these fees. And if we're lucky, that's it's a one and done. We stop there, nobody questions it, and we write the ship. So when it comes to screening fees, you are capped for condos by the statute. On top of that, your governing documents have to provide for the right to charge a transfer fee. So oftentimes you'll see, oh, they can charge $150 or the highest amount permitted by statute. You have that language in there, you're golden. I will say this though, if your documents provide for a lower fee, so generally speaking, we see older documents say, oh, you're capped at $50. In my opinion, you are capped at that $50 and you would need to amend your documents to increase that. Now, if you still charge the 150, you're complying with the statute, but do recall that your governing documents are essentially a contract. And when people get into your community, they are in effect entering into a contract. So by charging that higher transfer fee than what's permitted in your documents, you are in effect violating that contract. So it's very important that you make sure, one, you can even charge transfer fees, and two, you are charging either the amount listed in your documents or you're not going beyond the, at present, 150 under 718. And I believe Chapter 720 has no cap on transfer fees, but again, it must be in your documents. The same thing applies to estoppel fees. They're all set by statute, the amounts you can charge, and there's a varying scale depending if they want to rush or if there's other information you need to include. If you want to charge fees for, move-in or elevator preparation or even a security deposit, all that has to be in your documents. Again, these are common things that I see communities think, oh, it's totally reasonable. If we have people move in, there's a chance for damage to the common elements. We want to charge a fee. But again, if your documents don't support this and somebody pushes back, oftentimes what we'll see is in an application, they'll have all these fees you got to pay. And owner says, I'm not going to pay these. The association denies the applicant, and then they get sued. And we find out, hey, by charging these fees they couldn't charge, resulting in denial, we now have an unreasonable denial case that we're defending, and it doesn't look good. So for a lot of things, especially these, you need to make sure your declaration or bylaws provide for a security deposit and transfer fees. Now the application. So when you're reviewing these applications, it's very important first that these applications are obviously thorough. Now, if you're using programs like tenant evaluation, it's the only one I can really think of at the top of my head because I see it the most often. It'll have a lot of boxes, so to speak, for applicants to fill their information, but it's up to the community to add in their own documents that list things like use restrictions, parking rules, occupancy restrictions. All those things should be in the application so that when they answer those questions, we can quickly flag, hey, as an easy example, our documents say, owners get or residents get one parking space and there's no extra spaces. If we have an applicant who says, I have three vehicles, we can quickly flag, hey, if we were to approve this and they don't have, some sort of plan for those two other vehicles and they plan on just parking in the community, we know that if we approve this application, we are in effect allowing a violation. That's not to say we can't enforce after, but it's better to catch these things beforehand so there's not more issues we have to deal with later. So it's very important that these applications are thorough. Again, they should list the names of the people who are going to occupy the unit, what their intended use of the unit is. Obviously, they're probably not going to disclose, hey, I'm going to use this to, sell drugs out of. They're probably just going to say, oh, it's a residence. But again, we want to be as descriptive as possible so that our records are as thorough as possible. We can include things like references for income and financial solvency. You can have them put in a residence history. Obviously, you want to put in that they're consenting to obtain a consumer report, meaning we can do a background check. You want to make sure your application lists other documents they need to include, if that's some bank statements or references. If you're a community that allows things like pets, you can put in that you need to fill in a pet registration form, provide proof of vaccination, give a picture of the dog. And then again, tracking use restrictions, you want to make sure that a copy of the rules and regulations, or at the very least, the common things are included on the application so people can't say, oh, I didn't know about it. They know that when they're submitting their application, these are the things they are responsible for. Again, these are people who are residing in our community, whether they're a tenant or a purchaser. These people, if they're going to live in the unit, our residents have to deal with. So it's important to have as much information as possible so we can properly evaluate whether they would be a good fit for the community. Now the interview. So I am personally not really a fan of including interviews as part of the process for screening, absent it being a point where we've already basically approved the individual. So these would be more so, in my opinion, to be safe, more like a welcome or an orientation for residents. The reason being is the moment you see them face to face or you speak to them, let's say they're denied after the interview, you are essentially giving them potential ammo to use, let's say it's a discrimination case. So they come in for the interview, everything on the application checked out, but all of a sudden they're being denied. They might have a basis to claim discrimination, which is something that we want to avoid because if we mess up this process here, we might be getting a fair housing complaint or something from HUD, which is obviously something we want to avoid here. But if you're going to have an interview, same thing with screening committees, we want to make sure that they are properly created, meaning that at a meeting, a board meeting, the members are identified or a resolution is signed by all the board members establishing the committee and their members. This is mainly so that if, let's say, there is a claim involving a committee member, we can make sure that, hey, we have proper documentation showing they're a part of that committee, mainly for directors and officers or insurance purposes. Now, when it comes to the interview itself, again, it's very important to have established procedures. So every interview is treated the same. Again, a common theme for a lot of the classes I teach is we want to be consistent. The moment we shift from that consistency is the moment things go wrong. And if there's a lawsuit and they can show, hey, this was treated differently, that adds more credence to a potential discrimination claim or improper denial. So when it comes to interviewer screening committees, again, it's important to have either a meeting to establish them and its members, as well as their procedures, or by a resolution, establish those procedures. For the actual interview itself, it's very important that, again, everything is well documented. If they take notes, keep them as plain as possible. Like, oh, John Smith showed up at 11 o'clock. You give some brief notes of what they talked about, and, interview ended at 12. Very simple notes. The good news is with a lot of these leasing and sales documentation we're getting is while they should be maintained as a part of the official records of the association, they are not subject to inspection by the members. Information and documentation obtained in connection with a sale or lease are things that are not subject to inspection. But obviously, if we have some sort of complaint, we want to be able to have that information to show if it comes up through discovery, hey, we treated this lease or sale the same way that we treated every other sale or lease. Obviously, again, fair housing. For a lot of these things, we want to avoid a fair housing complaint. So consistency and fair screening are very important. And again, you also want to follow that timeline. Now, allowable options. Going back to what I said earlier, it's very, very important to confirm what you can and can't review. Sometimes you'll see that, associations only have the right to require owners to provide, a copy of the lease, and that's it. Sometimes they don't even have transfer authority at all. And at that point, if you have nothing in your governing documents, your declaration saying you can even review or approve or deny a conveyance, if it's silent, you are just exposing your association to potential legal claim by continuing to take in transfer fees or even review these applications if you don't have that authority. On top of that, you might only have sale authority. You might not even have lease. Or if it just says sale or lease, then you might not be able to review a gift, meaning like like a husband to wife or friend to friend transaction, or even operation of law, meaning like inheritance or through foreclosure. Again, it's very important to talk with your counsel so that they can confirm what you can and can't do. Because again, I've had times where a board will deny a lease. They get a nasty letter from an attorney. I check their documents and, oh, wait a minute, you can only deny sales. You never had the right to deny this person in the first place. Now, again, check your documents. There's going to be, unfortunately, most governing documents are not clear, but I have found that a lot of times you'll see very similar language. You'll likely see, oh, to ensure a community of congenial residents, blah, blah, blah. That usually is the precursor to your association's sale or leasing or conveyance review provisions. Now, one to keep in mind when you have a sale, and again, as I mentioned earlier in the webinar, the right to alienate a property is absolute. And as part of this, like I said, you can't really unduly restrict the right to sell. In the old days, and there was a case on this, I believe it's Aquarian House or Aquarian Foundation versus Shalom House. It's when the court addressed the community that basically had an unrestricted right to deny sales. If they denied a sale, that was it, and that's how they've been operating. Well, they were sued, and the court found that without a right of first refusal, the right to review and deny sales is unconscionable. So what this means is the right to refuse a sale of a unit is essentially married with the right of first refusal. So what this means is, let's say John Smith submits an application to sell their unit. The board would prefer not to have this sold to, 123 LLC, and they deny the application. Well, what this means is by denying it, the association is now on a clock where they have to either, one, buy the unit themselves, or two, find a substitute purchaser to purchase the unit at the same rate that was in the original contract from John Smith to 123 LLC. Now, as I'll get into later, there are some ways to deny a sale without triggering that right of first refusal. That's that good on the very bottom of the slide. You'll see good cause to reject. In most cases, for leases and other kinds of conveyances, like a gift, you're not going to see in your documents a right of first refusal. But if you do see one for leasing, I would talk to counsel, but it might require you, if you do deny a lease, not for good cause, you might have to find a substitute renter. If you fail to do so, essentially that original transaction would, in effect, be approved. So then notice the applicant. So when it comes to denying these sales and leases, again, talk with your counsel, but your local county ordinances might put additional obligations on you. So at least in Broward County and Miami-Dade County, within 45 days of receipt of an application, you need to provide a notice to the applicant or the seller and the buyer or the owner and the tenant that the application was denied for whatever reason. You have to also give a kind of vague basis for the denial. Now, I will note, at least in Broward County, The ordinance was recently amended, I believe in 2023, to remove the requirement to inform the lease applicant, so the tenant, the reason for the denial. So check with your council because the local ordinances might modify what you can and can't do and what you have to do. If you fail to follow the ordinance, you run the risk of a potential legal challenge. And again, your documents might have a different time frame, but you want to make sure you comply with everything as best you can. So for a lot of things, especially things like sales, where there's a lot of money at stake, if you have any questions, talk with your counsel. And again, going back into this adverse action notice, this is essentially the denial letter. It must be in writing. It can be by email. It can be by certified mail. It needs to list the credit reporting agency used for the background check. And it also has to have language saying, hey, just so you know, we did use, background check 123.com, but they did not make the decision to deny the applicant. But it was made in part because of the consumer report we received from 123 background check or whatever I called it. So I will say most of these application programs, again, I keep saying tenant evaluation, they likely have forms you can use this adverse action notice that are hopefully compliant that they can send automatically to the applicants or the purchaser, seller, whoever it may be, that comply with these requirements. If they don't have these letters or you yourself don't have these letters, again, I suggest talking to your counsel so that you have the proper documentation and forms to ensure that when you deny an application, it's done correctly. Now, document management, again, when we're getting these applications in, there's going to be some sensitive information listed. Obviously, like I said before, these are part of your official records, but under 718 and 720, information and documentation received in connection with the sale or release is not subject to inspection. So what this means is that when you get these documents, save them, but save them in a separate location so that they're not easily accessible. These are things that you'll use if we need to refer back to, let's say we approve 2 occupants, but all of a sudden a third person shows up. We want to confirm, hey, when they submitted this application, it only listed 2 people. And now we have that document trail. But at the same time, if an owner does an official records request, says, hey, I want to get all the documentation pertaining to the lease of unit 111, there's very little we have to give as part of that record request. But again, it's important to maintain these things in a separate but secure location because, again, there is sensitive information on here that we don't want to leak, but we want to be able to use if we need to. God forbid there's a claim and we need to refer back to it. Now, good cause. So you might have heard this if you spoke to your counsel, but something that at least I recommend and my firm recommend if you do have sales, leasing, conveyance, approval authority, is you also consider adopting what's known as good cause criteria. So as I mentioned earlier, when it comes to a sales application, if you reject them, sometimes you may trigger that right of first refusal, meaning you have to provide an alternate purchaser or have the association purchase the unit. Thankfully, that's not always the case. If you have this objective good cause criteria adopted, ideally through an amendment to your declaration, but in most cases, you can also adopt it through rules and regulations, meaning the board would adopt it. Again, I would talk to your counsel to confirm whether you can do that. If you have this objective criteria and you deny someone based on that criteria, you very likely have prevented the trigger of having to purchase the unit or find a substitute purchaser. Now, this good cause criteria, not only just for preventing the right of first refusal, also helps guide your screening and interview committees on what they should be looking out for when evaluating an application. So oftentimes when we do these good cause criteria policies, we include things like criminal history. So if someone has a history of violent crime, or fraud or financial crimes that are fairly recent, those are things to consider. I note that the slide does say the HUD guidance memo. I believe in 2025, maybe 2023, I think actually probably 2025, the current administration actually removed this guidance. This was the criminal guidance memo from HUD, which basically said that, hey, when you're evaluating applications, solely using criminal history to deny people might have a disparate impact on certain protected classes. That is now gone. I would still say act as if it was still in place. There hasn't been any replacement instructions from HUD on how to treat these things. But as a good baseline, if you see a felony that's more than, let's say, 7 years, obviously if it's a heinous crime like murder or, felony battery, it might be more relevant. It might be something you consider. But if we're looking at a small drug possession charge from 20 years ago, I would be careful using that as a sole basis to deny an applicant. Financial history and credit score, obviously, if you have a sales application, it's very important that the people coming in your community are financially sound so that they can pay their assessments. Because if someone doesn't pay, everybody else suffers. Plans get, you might ruin your plans, might cause special assessments, whole slew of reasons why we want people to pay their assessments. So it's very important we want to make sure that they have good financial history. This could also mean having, debt to income requirements. It could have certain credit score requirements. But I would say for credit score, this is one that is very popular with some of my clients. They want to set up a minimum credit score. This is the kind of thing where if you yourselves want to set up a minimum credit score, you speak to your financial advisors, see what a good credit score for your community is, because you might have a community where you have very low end units and they want to set like an 800 credit score, which in effect means nobody will be buying or selling or leasing in their community. So you want to have, like any rule or regulation, have it tied to a reasonable basis that fits your community. Because at the end of the day, if we have this 800 credit score, we deny an applicant, the owner sues. Now I need to go defend to a judge why this community with, low income homes suddenly needs an 800 credit score. It just doesn't add up. Again, this is the kind of thing for financials. You want to talk to your financial advisors, see what's a good fit for your community that will ensure that, hey, we're still allowing sales and leases, but we're also making sure that the people who come in are financially sound. Now, going back to credit score, it's not as important for tenants. Obviously, they're not fully responsible for paying assessments. However, under Florida law, if the owner fails to pay their assessments, most associations have the ability to make a rental demand on a tenant, where we have to send a letter to the tenant saying, hey, your owner's delinquent. You need to start paying your rent directly to the association until we tell you otherwise. So there is some incentive to make sure your tenants are also financially sound, not only because, hey, if they can't pay their rent, then the owner can't pay their assessments, but also so that if the owner doesn't pay their assessments for whatever reason, we can go after the tenants to get some of that money back. Another thing is we want to make sure that our good cost criteria establishes that, hey, if the applicant, for one reason or another, conflicts with our documents, it's another avenue for us to reject them. So, as an easy example, let's say someone sends an application in and they have a massive, massive pickup truck. If we're in a condo and we have small parking spaces, this is why it's important to have your application be thorough. If they say, "Oh, I have a massive pickup truck," and you realize that that's not going to fit in our parking spaces, and you ask them, "Hey, you can't park this vehicle here," and they say, "Oh, I don't care. I'll park it on the grass." It's very clear they don't have a proper intended use for the unit, and you can deny them. Another common one is, let's say they submit an application, they have two dogs, and they submit no paperwork showing that it's a service animal or ESA, or they themselves even say, "Oh, no, these are just my dogs." If your declaration says this is a no pet community, you have a basis to deny them on the basis that, hey, if they were to move in, they would be an automatic violation of our governing documents. On top of that, especially for lease renewals, and you want to be clear your documents allow you to review lease renewals, you want to make sure that there's language in there in your good cost criteria that says, hey, if they have a history of non-compliance with the governing documents, we have the right to reject them. So if you have someone who's, while living in the community as a tenant, they are constant nuisance violations, and there's a documented history of these violations. So please, this just came up with one of my communities where we had a board who wanted to deny a lease renewal. You want to make sure that they wanted to deny it on the basis that these tenants had violations. Well, they come to me and they say, hey, we want to deny them, send them a letter. And when I ask for support, like, hey, did you send them any violation letters? Anything in writing? And they're like, oh, no, we just, we talked to them once saying, hey, stop doing this. That's not going to cut it in most cases. You want to make sure for any violation, it is well documented so that if we do deny them, let's say the owner sues saying, oh, I lost out on money because of the association's unreasonable denial, we can say, oh, no, no, no. Look at this well documented history of violations. We have the support to back up our denial. So if you don't have them already and you have been reviewing sales and leasing applications, I strongly recommend, if nothing else in this class, you speak to your counsel about getting good cost criteria adopted because again, it can help protect you from that right of first refusal being triggered. And also importantly, it allows for consistent review of these applications because you have criteria that the leasing or screening committee can base their decisions off of, or the board, whoever's reviewing these applications, has objective published criteria that everybody's on notice of. If I'm applying, I know, hey, they have a certain debt and income requirement. I don't meet that. I shouldn't even apply in the first place. Now, some hot topic considerations here. So I don't really litigate anymore. I don't go to court as much anymore. But one of the things I dealt with in the past was suing people for unapproved occupants. Now, most documents do allow lease review and approval authority, but they might not allow occupancy review. So one of the cases I dealt with involved a potential lease. The board kept saying, hey, this person has an extra occupant living with them. They were not approved. It's definitely a lease. Their documents were very specific. Sales and lease approval was the only thing that they could review or deny. The owner's response was, no, this is not a tenant. This is like a live-in healthcare thing. We're not paying them to stay here. We are paying a business to have them provide healthcare. They don't stay overnight too often. Regardless, they are not tenants. That's what their position was. Now, the issue you might have here is, well, if we're suing them to say, hey, you have an unapproved tenant living there, we have to demonstrate, hey, this is a lease. And we have the right to approve or deny leases. They never got approved. They should be gone. We have to prove that. And if we can't prove there is a lease or some sort of conveyance or, consideration paid for occupancy, we have nothing to hang our hat on. So it's very important that, one, we make sure everybody applies, and two, it's very clear what the arrangement here is. Now, same thing with use of the unit. If they say, "Oh, I'm going to, work out of my home. I'm going to live in there and work out of my home," we want to make sure, hey, if your documents are specific enough as to the type of use. Most things just say, "Oh, residential use." They don't really give much more information on that. But if your documents are specific, saying, "Hey, no commercial use of the unit is allowed," including working from home, which I'd be shocked to see, if the person in the application says, "Oh, I'm going to use it to sell, as a salon," we have something that we can say, "Oh, well, our documents say no commercial uses, you're denied." Now, transient uses, that would be things like short-term rentals or Airbnbs. If your documents are not specific enough, and this is something I see often where boards really dislike Airbnbs, if your documents don't prohibit these things, then you can't deny them. And often, in most cases, I'll see things where Airbnb tenants aren't even screened because owners think, "Oh, it's a short-term rental, who cares?" So you want to make sure that your documents specifically have language saying, hey, Airbnb or transient rentals are not permitted or still are required to be approved by the board. Restrictions against advertising, make sure your documents are also clear, like, hey, you can't list on those Airbnb services. Local codes, again, that's going back to what I said earlier about the ordinances. Every county is different, although some share certain similarities. Again, Broward and Miami, where I primarily practice, they both have this requirement of notifying within 45 days. Although, again, like I said earlier, Broward recently took out the requirement to let the tenant know if you're denying. Again, speak to your counsel before you deny an application to make sure that you're following those ordinances. And then for ADA considerations, again, that's if you get a modification request. But I will say in most cases, as a condo or HOA, the ADA doesn't apply. So again, if you see something weird in your application, like a modification or accommodation request, I sincerely suggest you speak with your counsel to make sure that you're doing the right thing here and you're giving it enough attention. Now, obviously, the last point here is when you're done, let's say their application's fantastic. You want to make sure that you give that certificate of approval, especially in a sale, because most times the title company will need that certificate to close. So you want to make sure your certificate of approval clearly states who the buyer is. When you set up your screening/leasing or whatever committee that does these things, you delegate who has the authority to sign the certificate. And you can also mention on the certificate, we're waiving right of first refusal. We are approving this person. We are done. You want to make sure it's in a form. Sometimes your documents require to be in a recordable form. Generally speaking, the title company will record that for you. But if you don't have a specific certificate of approval form, again, talk to your counsel. Again, if you're using something like tenant evaluation, it probably has a form for you to use already. Either way, you want to make sure you have a good form that you're using for every single sale or lease. And again, you should only issue those certificate approvals once you have all the documentation you need. You make sure that they have a proper approval. The board has signed off on it. Whoever has signed off on the application, everything is approved. There's no confusion. You have your ducks in a row, and then once everything is checked and you're done, you issue that certificate of approval. Because once you issue it, it is very, very hard to suddenly rescind it. You can't just say, "Oh, they lied on their application." Well, you already approved it, unless it's very egregious. Good luck bringing legal action to unwind that transaction. So that's a short and sweet screening process. I think it's better to have more time for questions if there are any. I can't really
We
see if
have
there's anything below.
plenty. We have plenty. Thank you
I
so
can't see
much,
the chat
Chris.
thing, so I have no idea how many there are.
Let's get into it. Let's get into it. So, I'm actually going to go just from the most recent slide and work our way back to kind of the beginning because we have some that have just come in the last few minutes.
And
So,
Marielle, if I may, before you do that,
please. Yeah, absolutely.
okay, we encourage everybody to stay for the Q&A. It's not required, but you will learn a bit more. So hang out if you have the time. But
Mm-hmm.
again, I just want to remind everybody it's not a requirement. And in the chat, we've already placed in there about 3 or 4 different times now the link for the required post-webinar attendance and evaluation form. So if you haven't already done that, click on that, fill it out, submit it. Then you'll have instant access to save Chris's slides that he just went over. And within a couple of days, as Marielle mentioned a couple of times, the recording, the review video will be on both kbrlegal.com and on acebytsk.com to review as often as you like. If you maybe you just like Chris's voice and you want to hear his voice, you can watch it as many times as you like. So with that said, I'll turn it back over to you, Marielle.
Yes, and I also see that Jeff shared in the chat before we do move on the evaluation form, I believe. Did we share it yet, Jeff? I thought I had seen it, but maybe not.
Yeah, I mentioned that we've shared it a few times, and I'll put it in there once
Yeah.
again.
I thought, okay, great. Awesome. And if for whatever reason you guys are not seeing it, just make sure you have that chat button open so that when it comes through you can see it. And guys, just make sure you're using the Q&A button for questions, right? I see some questions in the chat, but they'll get lost in there. So go ahead and put your questions in Q&A. We're going to take some questions right now. All right. So I wanted to start with Lorraine. No rental amendment, but occupants allowed due to no consideration accepted. Are there remedies beyond amending documents?
So trying to find the Q&A thing. So I can read the question here.
Might
No
just be
rental
down.
occupants allowed due to no consideration accepted. Are there remedies beyond amending documents?
Mhm.
Unfortunately, you can't just pass by rule the requirement to have occupants screened. So when it comes to occupancy review authority or anything where you can deny someone access or residency or sale needs to be in your declaration. So if you have it just by rule, you are you're probably fine until you deny someone and then you get an attorney. So this is the kind of thing where I would definitely talk to your counsel to see about amending your documents to ensure you have the proper authority so that you're not getting sued down the line.
Thanks, Chris. So let's see. I'm just going to go up from there and then we'll come back to the last couple that have been put in since we ended. So, Guillermo, applicant who does not have a legal status in the country, no social security number, no way to prove funds in the US, no verifiable job in the country, no social, we said no social. What is the path to follow in those cases?
So that happens quite often. If they have no social security number, no proof of funds, you can still ask for other documentation that supports their financial health. So, or have them provide, a background check from their country. Basically, they need to give you similar documentation. And you need to be careful because obviously, national origin might be a basis for discrimination that they can kind of hook onto. So when you get those applications, obviously get your counsel involved. But first and foremost, you should try to get like-kind documentation that supports their ability to reside in the community.
Okay, let's see. Renata, if the HOA docs allow a lease and there is only one person on the lease, does that translate to one occupant, or does the HOA need a specific list of intended occupants slash submitted slash approved?
If they are applying and they list one person on the lease and they don't list, oh, there's going to be like minor children, that's who lives in the unit or the home. If you see somebody else show up living there, they are unapproved occupants, and that is a violation. Obviously, if they suddenly have a kid show up and it's like their child, it's not as important. But if we have another adult occupant who wasn't a part of the leasing review process, that's an unapproved potential tenant here, and that should be enforced accordingly.
And what does somebody do in that case? Let's say they get married in that time. Somebody moves into the, are they just supposed to be notifying their HOA? What is the process?
Right. So if a new tenant, so to speak, gets added, they need to go through the screening process. Now, if it's somebody who, they don't go through the process, then again, you send your violation letter and you give them the opportunity to apply. If they don't apply at all and they say, I'm not going to do it, I don't care. Sometimes even the owner doesn't know. Again, you go through your enforcement mechanisms. So, depending on what your documents say, if your documents give you the authority to step into the shoes of the owner, you can actually go through the eviction process against the unapproved tenant. Most communities don't have that authority, so then speak to your legal counsel. Likely, what you're going to have to do is sue the owner themselves to get them to remove the unapproved occupant. But the first things first, again, the goal here is to know who's living in our community. So have them apply, give them the opportunity to apply. Obviously, if let's say they apply and they don't meet the requirements, you can still deny and they have to get out, but give them that opportunity. And if they don't apply, you enforce it as if it's an unapproved occupant and you treat it accordingly.
Makes perfect sense. Dominic, first right of refusal can be challenging with sales. Came across a situation, a owner in our condo made an offer within a 14-day time frame, which is a house rule if interested in the purchase. At the same time, an outside interest was also interested who had the first right to purchase.
I'm reading Dominic. It's going to be challenging.
Yes. Thank you.
That's an interesting question. So you basically you had an owner who was selling their unit, and then you had somebody in the community that had a right of first refusal who indicated they wanted the purchase, and then you had an outside third party. At that point, I usually defer to people who were within the community first. But again, we're basically offering both options here. Now, the outside party would obviously still be subject to approval, but at that point, if we're going to trigger the right of first refusal here, I usually give them the in-community person first, but both can be presented to the owner to consider. Because regardless, they are purchasing at the same market rate or at the same rate provided in the contract that was initially denied.
Okay. We have, let's see. Let's jump up to Edward. Can you put weight or size restriction on ESA pets? I would assume you can't for service animals.
So both ESAs and service animals, a good way to think of this is they are not pets. What this means is pet restrictions do not apply to either of them. So if I have a breed, if we have, no dogs over 25 pounds, no certain breeds, does not matter. I can come in with my 100-pound golden retriever named Killer. If it's an ESA, your pet restrictions don't apply. Killer's coming in. I have a doctor's note. Your pet restrictions do not apply to me. So what this, again, to answer your question, weight and size restrictions do not apply. There are very few restrictions you can actually implement that would be applicable to these ESA and service animals. Rules that do work are things like lease requirements, requirements that they don't go to certain areas to let the animal, do its business. You could enforce a rule saying, hey, the dog's not allowed in the pool or in the jacuzzi. But the best way to think about it is this dog, this ESA/service animal, is an extension of that person. So 90% of the places the owner can go, the animal can go as well.
Okay, great clarification. That can be a tough one.
Oh,
I
and
know you
one
guys
thing,
do a whole. Yeah, yeah, please, please.
or one more thing. And if you have any pet fees in your declaration, you cannot charge those against someone who has an ESA or service animal.
Oh, wow. I know you guys also have a whole class about this. You've presented for us
Yes,
before, so that might be, one that we bring back because there's a
that's a
lot to
good one.
cover.
And things are kind of evolving at the moment. Kind of like the criminal guidance we had from HUD, the one that I relied on a lot, and actually I used to teach this class, the service and ESA guidelines from HUD were recently rescinded as well. Um, how that plays out in practice, we're not sure. We're still waiting on more instructions, but it's definitely an interesting class to take at this time.
Excellent. I want to say hi to Lisa. Hi. Lisa
Um,
runs Ace by TSK with us, and I
You're
think she
very
might have a
welcome.
question.
I do, and I may have missed it because I was 10 minutes late, so forgive me if you talked about this, Chris. Um, can boards vote on changing credit score limits, or is it something that needs to be changed in the docs and completely voted on by the community?
So it depends on how it was adopted. So if you have that credit score in your declaration, and let's say it says, a minimum credit score of 650, and that's it, you're stuck with the 650. Now, if it was artfully drafted and it says 650 or as determined by the board from time to time, that's when the board has the right to change it pretty freely. If it's in your rules, then at same token, at least at that point, the board can freely change things. But again, if it's in your declaration and it doesn't have that from time to time language or something that indicates that the board can change this, then you need a member vote to change it.
So can I ask a follow-up?
Sure.
It's it's not quite that cut and dry. So what if the language is vague and just says has a, good credit score?
Yeah.
Good is subjective depending on when, like right now, a good credit score is different than it was 10 years ago. So
Right.
can we apply a number or do we get validation from credit agencies to say this is what's defined as good at this time, moment in time? Is there a way to handle that that's specific?
So I know certain credit agencies do have that scale where they'll say, oh, like 700 to 750 is good, and then like 760 to whatever is like excellent. That's a good metric. But again, since an actual number is not stated, I would say the board is within its right to really establish what that is, but it should be formally adopted by the board and published and available so people know, hey, a good credit score is at a minimum this number. And the
Okay.
board adopts it in the same way it would adopt a board-made rule. And again, it kind of to your benefit, the fact that it's so vague, it gives the
Right.
board the right to change
So a
that. Now,
little bit of
obviously,
leeway.
obviously, if you say, okay, if it says good and you make your credit score 850,
Yeah.
it's going to be hard to defend that. Oh yeah, 850 is just good, and the 750 credit score isn't good enough.
We have a question in this same realm from Agatha. Can you run a background check if you do not have it listed under association rules or docs? Do you need to create a rule?
So if your documents don't say anything like a transfer fee for background checks, but you still, if you have the authority as a baseline, if you have the authority to review and reject sales and leases, to me, that kind of leads to being able to do the background check because how else are you going to really be able to evaluate those applications? If you don't have anything in your documents to say, oh, we can charge $150 for that background check, well, then the association is basically bearing the cost of the background check as cost of doing business. I still think you can do it, but I would check with your counsel to see how it's worded to make sure that it doesn't say anything that conflicts with not being able to do the background check.
And I want to jump back up to the very top from Jerry because I think this is a good question or possibly a review for people. Can you expand on a transfer deposit application fee definition? How do they
Sure.
differ? We have transfer
So
deposit
transfer
application fee.
transfer and application fees are basically the same thing. Basically, transfer and application fees are any fees charged in connection with a sale or lease application. It's established by statute that if your declaration or bylaws provide for these fees, you can charge them. I believe under 720, there's no cap. So your documents should ideally have a number. And if they don't, then I would use 150 as a kind of a baseline. But for condos, you are hard limit at 150, regardless of what your documents say. So if your documents say $600 transfer fee, don't keep charging that. You need to go drop down to 150. Now, a deposit, that would be kind of a refundable thing. Let's say your docs say, oh, we can, for a lease, we can have 1 month deposit to protect against damage for the common areas that will be, or common elements, excuse me, that will be refunded at the end of the lease. That has to be in your governing documents. So transfer and application fees are the same thing. Security deposit is a separate thing. Both need to be in your documents to be able to charge them, although there's not as many caps on the deposit. But again, they're all they have your authority to charge them has to be in your documents. Other than that, they're different.
Okay. Um, is it okay to ask for 3 years of financials to ensure the prospective buyer is in good financial standing to afford the assessments?
3 years might be a bit excessive. I generally do a couple months, um, but it never hurts to ask. At a baseline, if you're going to start asking for extra documentation, I suggest you adopt a policy that shows what might be asked. Because if for one applicant you ask for 3 years, another applicant you ask for 3 months, that disparate treatment is something that will just nip you in the bud later. So definitely
Definitely.
something you should make sure you have consistent asks. Obviously, if there's some weird situation with one that gives a basis to ask for more documentation, then you're good, but make sure all of that is well documented and in writing.
I think you kind of answered this one a little bit, but Sharon asks, can the board pass a rule to charge fees versus it being in the documents?
You cannot. Florida statutes are very clear. It has to be in your declaration or your bylaws.
Okay. Glad we asked that
Now,
one.
I will say this. If your documents say the board can charge a transfer fee in connection with a sale or lease in an amount, as established by the board from time to time, the board then, by rule, could establish what that fee amount is. But if your documents are completely silent as to the authority to charge a transfer fee or deposit, you cannot do it by rule. I
Okay.
mean, you can, but when you get a pushback from an attorney or you're sued, it's going to be very hard to defend that.
From Charles, can applicant screening be recorded?
Are you sure? Yeah, you can.
Okay,
But
great.
again, these interviews or the screening, while I would suggest maintaining them as a part of your records, they are not the kind of thing that can be made available to owners who ask to see them. Because any information or documentation obtained in relation to a sale or lease is not subject to inspection.
Okay. Let's see. We have a lot of questions. You guys have some great questions today, and I know that the KBR team is usually very happy to answer questions after the fact. So we're going to get to a few more, but I also want to be respectful of Chris's time. So let's see. Um, uh, 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 we did talk a little bit about the negative credit report, but let's take this question. If the condo association is not offering any credit to a buyer where they can deny based on a negative credit report, I heard your argument that not paying assessments is a burden on the other owners. However, Florida law provides other remedies to resolve non-payment of assessments. From Scott Schlemel.
Honestly, is not offering any credit to a buyer. Why can they deny
Huh.
based on negative credit report? Not sure what you're asking here. The,
I
the
am
fact of the matter is, when it comes to someone not paying their assessments, you're right. There are other remedies, but that's a burden on the association having to go through the collections process. It might be over a year before we see any money from that unit if we have to go through foreclosure. Because the collections process itself takes months, and then the actual foreclosure process, when you're in court, takes a while as well. So while there are other remedies here, it's better to make sure that at the very least we're going to have consistent payments as best we can, so we don't have to rely on those foreclosure remedies.
Lisa, can you pick a couple questions to tackle next?
Sure. Let's
Great.
let's see. You've answered a lot. Um, yes. And let's see. I don't think you've answered this one yet about volunteer screening committee members signing certificates of sale, lease approval, when the declaration states two board officers must sign.
And then two board officers should sign. You want to, if your documents provide a strict process, you can vary it in some ways, but if the end result is two board members must sign, have them sign. And at a baseline, I would, no matter what, in most cases, the board is the one doing these things. But if you do have a screening committee, no matter what, I would still have the board involved. That way they can have their sign off and make sure if there's a an issue that D&O coverage does cover them.
Um, okay, that's great. Another question for you. Uh, okay. I have a question for you, which is around a lot of this. Board members have an obligation. Not all board conversation is for public publishing, correct? And
Correct.
and what do you do when you have a board member that um, and this has come up several times in the last couple of weeks in speaking with board presidents. So it seems to be a common problem, but I'm just curious what your perspective is. When a board member shares information about applications, documents that general residents are not usually privy to.
So at a
So I'll give you an example. Um, Somebody, and this was how the conversation started. Another president had commented to me and said, I'm really frustrated. I don't really know what to do. There was very sensitive information about this family, and they disclosed it to us because they were trying to be transparent. They were approved to live in the community, and a board member is now sharing all of that private information with their neighbors. I know. I
that's a
shook my head also and went,
So disclosing that private information is obviously a no-no, and these residents whose information was disclosed do have a cause of action against that individual. Um, just as a baseline, board member communications. So there's been recent guidance basically saying that, hey, it's not subject to inspection unless these are communications with like association management or using association email addresses. So if you have like president at homeassociation.com, if there are any communications from that email, most likely are subject to inspection. But if you're emailing, the president, Lisa123 at Gmail, emailing, Joe Smith 123, not very creative, those things are likely going to be private, even if you're talking about association business. So it's very important for board members, have your business email and have your personal. Now, going back to sharing private information, again, please don't do that. Depending on what it is, if it's medical, you might run into HIPAA stuff. There's a whole slew of things, but that's a remedy for the owners whose information was disclosed to really bring. And it might be the kind of thing where you need to censor that board member, maybe get them removed from the screening process because they have shown the inability to really not disclose important information.
right. It's a very unfortunate situation where if you are going to be a board member and you're responsible for helping to make decisions around your entire community and all of your neighbors, that just creates hostility, angst, a lack of trust, for the board, and none of that bodes well for culture and community.
Mhm.
Right. So if for those board members that are on here, please use discretion when you share information.
And
Use discretion
I'm gonna
and
be
be
the bad
consistent.
guy. Oh, sorry, Chris.
Oh, no, go ahead.
Yeah,
Go ahead, Jeff, all you.
I'm gonna be the bad guy here. So we're gonna do one more. We're past the top of the hour, so we're gonna take one last question before we let Chris get out of here and get to his appointments. So Lisa, you want to give him one more?
Yeah, I have a good one.
I have to go work.
Does every board member have to sign off on the tenant evaluation, meaning on the application for the tenant eval? For those of you that may not know, tenant evaluation is an actual system. Doesn't necessarily mean leasing or tenants, it's for purchase as well. But whatever system you use, do all board members need to sign off?
If your documents, for whatever reason, say the entire board needs to sign off on things, I would follow that procedure. Otherwise, if it's pretty open on the procedure, I suggest the board adopt kind of a policy on these things and designate a signer. That way you have one person or maybe two who are designated signers. Definitely have backups just in case. But again, absent any document in your declaration saying that they all have to sign, usually at a minimum, it's one person's fine,
Okay, I
if
have
any.
one more quick question. Are volunteers covered under D&O insurance?
So the all committee members are volunteers. I suggest to better protect yourselves when you establish these committees, you do so at a meeting and by a resolution that basically establishes what the committee's purpose is and who the members are. That way, they are formally designated as committee members so that if there is a claim, you can provide that resolution to insurance and confirm coverage.
Great. Chris, thank you so much for always for your time, your attention, your expertise, and your delivery, because your delivery is just great. It's not often that you have someone that has such a warm, engaging personality when it comes to the law, which is pretty black and white, has a lot of deep emotion for people around all of these issues. So thank you again. Great, great
No, thank you so much for
presentation.
having me.
I echo that statement.